Welcome to another episode of Litigator's Corner, and today I have with me from the UK, Peter Petyt. Peter, thank you for coming today.
Well, thank you, Hilary. It's a great pleasure to be talking to you.
Peter, tell us about yourself and what you do.
Well, my background is mainly financial, Hilary. I qualified as a CPA in the UK many years back and spent quite a lot of my career helping companies and individuals to grow or to sell businesses. That involved often us talking to private equity houses, banks, family offices, and other sources of finance to raise the money that was necessary. And that training and that methodology, I think, has informed what we're doing at the moment. So we're taking a kind of corporate finance approach to litigation finance. We believe it's quite a challenging asset class, and therefore you have to prepare the business case for something very carefully. And that means looking at all aspects of the case. This is what we used to do when we used to prepare companies for financing. So we're looking at the team of people, we're looking at the market opportunity, we're looking at the numbers, we're looking at any factors that influence the quality of that particular opportunity. And that's very much what we do in litigation finance, which I've been in now probably for about 6 years. And I fell into legal services about 6-7 years ago when I was asked by one of my clients to run their business to prepare it for a buyout. And I spent 2 years doing that. We did a lot of business development and origination. We did 3 acquisitions. We developed an IT strategy, and we had a deal ready, all ready to go, which was backed by a private equity house and a bank. That deal didn't actually go through in the end because there was a change of strategy by my shareholders. But it did introduce me to the world of litigation finance, which I found fascinating and full of potential. And as a result of that, I joined a litigation finance fund in 2015, spent some time there, learned a lot about the industry, and decided in 2016 to set up 4 Rivers, which is my current business, really as an advisory business, helping claimants and law firms and other parties to raise litigation finance, or to use the generic term third-party funding, which essentially is finance to help pay the legal costs and expenses of running a dispute. And we've had that business for Rivers since 2016. And we've developed the business now so that we're doing deals globally. So it's a pleasure to be talking to the West Coast of the US. But we do have claimants and law firms and funders that we engage with all over the world. So it's a very exciting business.
It sounds like it. And for our viewers, you work in an area that is very near and dear to all lawyers' hearts and all law firms' hearts, which is how do we get paid? And I think a lot of people, when they think about litigation funding, think about it's only applicable to a PI or maybe a med mal case, what you would call the consumer side. Can you tell us a bit about the difference between commercial litigation funding, which is what you do, and consumer litigation funding? Because I know this is really opened a new world for a lot of lawyers, particularly recently. I think they'd all like to hear about it.
Well, actually, litigation finance can be applicable to both consumer and commercial cases. There's a certain number of funders who will only do commercial cases and some who will only do consumer cases. So there's 2 different markets there, but they're equally served by the finance communities. I think the commercial finance community, which is, to be fair, what we spend most of our time on, are looking at the mainstream litigation cases, the international arbitrations, the domestic arbitrations, those sorts of cases. Whereas consumer often is, as you say, PI focused, or perhaps a higher volume type of case, but with a lower average value. But in essence, where the case has a potential successful outcome, there should be a financing solution available for it. And as I mentioned, different funders have different appetites. So we're, as 4 Rivers, we're interested in the whole market, and we have funding sources that would provide solutions for the whole market. What we're particularly interested in is helping law firms, as you say, to get paid properly. So our toolkit, I suppose, of financing solutions is always looking at how the law firm is going to get paid and whether they are going to have enough cash flow whilst they're running a case to pay their bills, keep their salaries up to date, and basically keep themselves healthy as a firm. That's always foremost in my mind when I look at crafting a solution.
And what I know that we've talked about this, Peter, litigation funding isn't just for situations in which a litigant can't afford the fees of a firm. It's also just an important tool to have in the arsenal of any law firm to recommend clients. Can you tell us why that is?
Well, I think it's very interesting, particularly in the current period where, of course, because of the pandemic, businesses in particular are chasing challenges that they weren't a year or two years ago. It does mean that cash is very much at a premium. And certainly we're seeing a number of businesses now that are looking to finance their litigation externally, whereas perhaps previously they would have funded it from their own resources. So I think cash is definitely a main driver. Most of the cases that we look at, the claimants are looking for a solution from a cash flow point of view. They either don't have the cash to pay the legal fees and expenses of running a case, or if they do have the cash, they'd rather use that cash for their core business. And I would say that's still the majority of requirement. However, sometimes a business may well decide that there are other reasons for bringing in a third-party funder, such as, for example, accounting. The great thing about using third-party funding is that you can keep the transaction off your balance sheet, and that means that the risk is not there in your balance sheet. You can keep the litigation costs away from your profit and loss account. That's going to make your profit and loss account larger, of course, and that often helps, particularly if you're selling a business, with the valuation of that business. It might help with bank covenants as well, particularly where the bank covenants are based on EBIT or EBITDA, profitability measures, those sorts of things. So there can be other non-cash reasons why someone might choose to bring in external finance for litigation.
And Peter, I know that we've talked about, there's a growing trend in the legal community to look to litigation financing. What kind of growth have you seen in this industry in the last 5 years, and where do you see everything going?
Well, it's a really dynamic market, Hilary, and an exciting market as a result of that. I suppose litigation finance has been with us now for a little under 15 years, but certainly, like in many new nascent markets, there's an initial period when the growth is perhaps quite modest, as people are looking at the funding, looking at the asset class, getting familiar with it, seeing that there's a track record, seeing some kind of proof of concept. And I think that period probably took 8 or 9 years for the asset class to become very well known, people to become more aware of it. And as a result of that and the successful returns that were noticed in the market, I think in the last particularly 3 or 4 years, there's been an influx of capital into the industry because people are now seeing this as a very attractive asset class. And unlike putting your money in the bank or investing in gilts or fixed income instruments, the returns you can get from litigation finance are very compelling. There's a lot of risk attached to it, but equally the returns are very good. So certainly in the last few years, we've seen a very steep growth in the industry. And the last data that I saw on this suggested the industry would probably double in size in the next 5 or 6 years. So depending on what data you read, probably the industry is around $12-13 billion at the moment, maybe a little bit more. That should double in about 5 or 6 years' time. So really dynamic industry, a lot of growth, a lot of new players coming in, a lot of money coming in from perhaps newer sources like family offices. Certainly the hedge funds are beginning to invest. So we're seeing a lot of growth. And we obviously see this because we sit in the advisory space. We see that as a very exciting opportunity because there's now a lot of capital available. The key is obviously to make sure that opportunities that are presented to the capital providers are properly advised and properly structured.
And Peter, what skill sets does Four Rivers bring to a deal? And what advice and services do they provide to a law firm or a claimant, whoever they're advising?
Yes, that's a great question. I think, as I mentioned earlier, we take a corporate finance approach to litigation finance because we believe that, in fact, we know from talking to the funders in the space that still it's a very low percentage of opportunities that are actually funded. And one of the reasons for that is that the opportunities are just not presented and packaged in the right way. And that's really where our raison d'etre is, to come in and help present and package the opportunities so they're investment ready. But that can mean a number of different things. And often we are asked, actually at a very early stage, perhaps directly by a claimant, to help us put together the team, which includes the attorneys, the experts, other advisors, to take the case forward, to do an analysis of merits, to do an analysis of damages, to do research on the defendant. There's all sorts of things that need to be done to get that case to a point where we would recommend you take it to funders. And we're obviously involved in that, in selecting the people, in helping put together the right sort of fee structures, all of the things that are required to get a case investment ready. So we approach it very much from a corporate finance standpoint. We're happy to come in at different stages of development of the case or cases. And if we're advising law firms, which we are doing increasingly, we see it very much, again, as a corporate finance exercise where we're taking a business that's got quality and a lot of potential, but it needs to be packaged in a certain way. And there needs to be quite a lot of number crunching done to show how the numbers will work. There needs to be a lot of analysis of the skill sets of the law firm, its track record in certain types of cases. And certainly we'll come on to it in a minute, I'm sure, portfolio funding, where a law firm is presenting a bundle of cases to a funder to receive financing. That needs to be done very much as a proper business case with a proper model. We get involved in a lot of areas. I think the numbers piece is always an important part of that. And certainly we have quite a large network now of, for example, damages experts who we often bring in to help validate the numbers that are being presented. I think if you ask funders, perhaps the single most thing that they think maybe sometimes is lacking when cases come to them, it's a proper damages thesis. So we're very much at pains to work with the attorneys to develop that, so that when the case goes to the funder, that damages number is validated. And we know, therefore, that the numbers will flow from it.
Peter, but you'd mentioned the single versus the several case portfolio. Can you tell us, our viewers, what the difference is there? I mean, it probably seems self-explanatory, but I think hearing it from an expert like you would be better.
Yeah, well, single cases are difficult to finance. Let's start off with that, because the thing about a single case is that you're either going to get a win or a loss from the single case. And you can't diversify that. It is what it is. It's a single case. In a portfolio, you can spread the risk over a number of cases. And the great thing about that is that then the price of the finance is significantly reduced, because if one case doesn't go the right way, then you can get the win from the second case or the third case, or however many cases there are in the portfolio. So funding a portfolio is going to bring the cost of the finance down. But it's also quite challenging to get a portfolio funded, because the portfolio needs to be structured in a certain way. It needs to be balanced. It needs to be, in some cases, a mix of types of case that are part of the portfolio. And one of the things we are doing, actually, one of the things I'm personally doing, is some part-time doctoral research on how portfolios should be structured with regards to a law firm. So we're looking at what the ideal law firm portfolio looks like, why that would be attractive to funders, what elements need to be in place for it to be attractive to funders, and how it might work certainly in different jurisdictions. And of course, in the US, there are lots of different challenges according to what state you're in. So clearly, I'm talking to you guys in California. The same challenges don't apply in California, for example, that apply in New York. So there are different jurisdictional issues, but generally speaking, now the litigation finance industry has grown up, I think, and is finding ways to structure deals, whatever state they might be in. But there are different challenges according to each state. So yeah, portfolios I see very much as the future. I think law firms benefit hugely from getting portfolio finance because it allows them to offer competitive but lucrative fee arrangements to their claimants. It very much allows the law firm to own the relationship with their claimants. So you just sign one piece of paper with them, which is your contingency fee. What you then know is in the background, you've got finance available to help your cash flow and pay the disbursements as well. So it's a good solution.
And Peter, I know that we're going to talk about the process here that you go through when you put together a deal, just so our viewers can learn about it. But what can we as lawyers or heads of law firms do to make this process a lot easier? As we all know, when working with clients, it would just be so great if our clients could put all this together. And in this case, a law firm is in respect to client. What can we as lawyers do with respect to the due diligence and the assessment process, as well as the funding and the post-funding, that they can make this go a lot more smoothly?
Yeah, it's a great question. I think that from the attorney's point of view, where I would start is that your expertise is in running these cases and using your great judgment to assess cases and to advise your clients on the best way forward. And certainly one of the things that funders need is a proper legal assessment from you guys as to the merits of the case. What chances of success does it have? What strengths, what weaknesses are there that you perceive in the case? And that, I think, is the most important part that the attorney plays in the initial due diligence for a funder. What people like me try to do then is to take your work and then build lots of other things around it that are necessary for the funding to be viable. And certainly, I use budgets as an example for that. The litigation funder is always going to want to see a budget because they're going to want to see how much money is required, what it's going to be used for, and what stages of the case it's going to be used at. Because one of the things a litigation financier is going to want to build into the case is if something happens that has a negative influence on the case and maybe stops the case going forward, they'd rather limit the amount of money they spent to that point.
Yeah.
So one of the things we do is work on a phased budget to show what money is going out at what stage, and that helps the funder's risk assessment. So we do a lot of work on the numbers. I mentioned damages before. We really do try and work with the attorneys to work up that thesis. We do work on sometimes the defendant, their capacity to pay, do some research on that for working with you. So we add all the bits around the outside that probably are not directly related to the legal merits, but the merits piece is very much in the hands of you, the expert attorneys. So we're relying on you for that. We're not giving legal advice. We're very much relying on you for that. But all the other stuff around the outside that you probably don't want to spend your time on, that's something where we play a role.
So Peter, I know it's a complex process to do an overview of a deal from start to finish, but can you sort of give us a quick summary of what a person or a client or a law firm or a claimant can reasonably expect once they get you involved in the process?
Yes, that's a great question and a difficult one to answer because it's genuinely true to say that no one case is the same. And there are a lot of variations in terms of timing depending on the stage that we're brought in at and what type of case it is, whether there are any external factors perhaps that need to be resolved before the case can be taken forward. But I suppose as a rule of thumb, if the case is quite well developed when we're asked to be involved, and by well developed, I mean that you've done your assessment of the legal merits, you've done your assessment of the case and its prospects. and we can come in and we can get hold of the other information we need, we can do the budgets with you fairly quickly, then I think the whole process from our involvement to actually getting funding, if everything goes incredibly smoothly, it probably can be done in a couple of months. But I would say on average, it is longer than that, because normally there are factors that take some time. That may be that, for example, if we have to get a damages expert involved, bringing that person in, allowing them some time to do their work, even if it's just a summary piece of work before funding, that will take a couple of weeks normally. So I usually say to people that 3 to 6 months is about the average, but I think it's nearer the 3 than the 6, just to give you some reassurance. However, I mean, I would also warn you that some cases that are particularly complex or that need a lot of preparatory work before they can be taken to a funder, in that case, it can take a lot longer. And certainly if we get a claimant coming to us who's never spoken to an attorney before about the case, then you could be talking, many months and potentially over a year to develop that case. So it really depends at what stage we're brought in at and what is required to get the case investment ready.
And does Four Rivers stay involved after a case is funded?
We do. This is a part of our model that we're extremely keen to promote, because whilst we acknowledge that obviously we have competitors, we believe we're a bit different, mainly because of the corporate finance background we have. So we're very invested in the case, and part of our fee is always associated with the end result of the case, which obviously we hope is successful. So once the funding is in place, we're very much involved. We're available to help in whatever way we can. That can mean all sorts of things. It can mean managing the relationship between the attorney, the claimant, and the funder. It can mean sometimes revisiting the budget where there perhaps has been a change in strategy along the way, and perhaps there needs to be some kind of rejigging of what cash is needed when. It can mean perhaps doing some research where perhaps the defendant status has changed, and really anything else that's required to help the case run smoothly that perhaps it's best that we do rather than the attorney or the funder. And in fact, funders really like us being involved, because we do therefore act as that piece of glue that holds everything together whilst the case is moving forward.
Peter, I know that you and your colleague Wilmar did a lovely presentation the other day, and in it we discussed the fact that sometimes a firm can lose out on a client altogether if they are not prepared to discuss and don't consider litigation funding an option. Can you tell me a bit about that?
Yeah, I think it's very important that you as an attorney advise your clients as to what the options might be, because certainly sometimes there are clients out there who, as we mentioned earlier, might have the money to pay for the legal fees and expenses of a case, but might prefer to keep their cash for other purposes. So if they're not aware that litigation finance exists, if you as an attorney don't advise them and they go and talk to some other attorneys who do advise them, then the chances are they may well end up with the other attorney. So I think it's very important to make them aware that this option is available. They may not wish to take it, but if the option is available, then potentially you could hire, for example, someone like us, or the client could hire someone like us to go and help them put that financing in place, so they've got that financing available to pay the legal fees and expenses. Or, of course, if you're a law firm and you have a portfolio facility in place already, you can add that case to the portfolio and have financing in place to help your own working capital. So there are various ways you can do it. I think the best thing to do is always to say to the client, look, there are various ways that we can do this. You could either pay for everything yourself, or we can offer you a contingency arrangement, or we can ask someone to come in and help get external financing, or even a mix of those things. So what I would always say is do talk to people like us early, so that we can tell you, based on what you've told us, what we think the options are and what's achievable and what's not.
I know that, Peter, your company provides really Rolls-Royce services. Is something really to be proud of. I know a lot of attorneys may be thinking, why does this apply to me? Why if I have a case that's worth $100,000, $125,000, and you're dealing with much, much larger numbers. Are there a range of litigation funders that will work with attorneys and firms that have smaller cases?
Yes, so the market, because of the growth that we're seeing now in the market, the great thing about that is that there's quite a diversity of types of funder with different types of appetite. Certainly, as a rule of thumb, it probably gets a bit more difficult to get someone interested if the case is very small. Having said that, there are certainly funding sources available now that will do the smaller requirements, particularly I think where an attorney might be prepared to offer their services on a contingency basis, but that perhaps there's a need to pay some outside costs like an expert or a court fee or some other disbursement. And so, for example, if the attorney says, look, I'm happy to do this on a contingency basis, but it's going to be $75,000 to pay some people, so some experts or some external costs, there are sources available that would cover those disbursements. So from our point of view, that's probably a little bit small for us to be involved formally, but we're always happy to help. We're always happy to make introductions. And where we feel that maybe we can add some value later in that case or in another way, we'll try to find a way of making that arrangement happen. So again, we're very happy to be consulted. We're very happy to try and find a solution.
And as all of us as lawyers know, often costs can be a substantial part of any kind of case, and the client looks at it and is just dumbfounded to see how much the cost, just not even the fees, are going to cost to take a case trial, particularly when there are depositions and experts and travel is involved and things like that. That brings me to another point, Peter. Now, yours is certainly a very well-respected and established company. Not all advisors and litigation funding companies are. And how do we tell what company is a good one and what ones are ones we should just not do business with?
Well, I think as regards advisors, probably the best thing to do is to try and take references. So obviously, if people would like to do that with us, we're very happy about that. We have, I think, some very happy former clients and former people that we've worked with. So we're more than happy to clearly offer some references and attorneys we've worked with before, funders we've worked with before, damages experts we've worked with before. Very, very happy to do that. And I think on the whole, we'd like to think that we're, as you say, quite well respected and the value has been perceived. I think as regards funders, that's clearly something that I would have a view on because we are dealing with the funding market on a day-to-day basis. And as I mentioned, there are now a much greater number of funding sources than there were 1, 2, 3 years ago. So I spend quite a lot of my personal time talking to funders, making sure I'm aware of what their sweet spots are, what their investment criteria are, perhaps where there's a real appetite in their portfolio to take a certain type of case or a certain type of opportunity. So I would say that we're in a pretty good position to give a view on funders. Most of the funders out there are credible. Most of them they have good teams, have good experience within the teams. They may not have a track record or much of a track record yet because a lot of them are quite new. So to a certain extent, you're going on the quality of the team, you're going on soft things like their marketing material and how they present themselves. And of course, you can also take references from people they've funded themselves. But I think the key thing with a litigation funder is to make sure that they have got the money to fund the case all the way through. Because the way it's normally structured is, let's say it's a single case and it requires $2 million worth of finance. They're not going to write a check for $2 million on day one. That's not the way it works. As I mentioned earlier, there'll be a budget and there'll be drawdowns on a monthly or bi-monthly basis of that money. The worst situation is that they're good for a few months and then they say, oh, we haven't got the money to carry on. So again, we make it our role to make sure that the funders that we deal with absolutely have, if they commit to an amount of funding, that they've got that funding available and they will keep it available. they write they'll sign a contract to say that that's what they've got to do, but you've got to make sure that they can actually resource it. So, and sometimes it's quite difficult because funders, a bit like private equity, do have offshore structures. So it's not easy sometimes to sort of dig a set of accounts out and to see that there's a lot of money on the balance sheet. There are some funders who are quoted on public markets, so that information is more easily available. So yeah, we do have to do some research and some referencing ourselves to get comfortable that a funder is credible and good for the money.
And I know that we have talked about situations where people will go through that funding process and they never receive a check.
Yeah, I mean, sadly, it has happened. There are the regulation in the industry. We haven't got time to talk about that during this session, but it's an evolving feast that, and a lot of the industry is self-regulated at the moment. There are a couple of associations. We have one here in the UK called the Association of Litigation Funders, and there's another one just been launched, a more international one, which has the potential, I think, to be very useful in the industry. And there is a move towards regulation of some sort. But yeah, I mean, it's an important point. You want to make sure that the funders you're dealing with are properly structured, they're credible, that they adhere to certain codes of conduct, because they're going to be a partner going forward. I mean, this is the key thing. They are going to be a partner in the case, and you want to make sure that they've got the right resources to be a good partner.
Exactly. If you wanted anyone to take away from today's Litigators Corner, what would you want takeaways to be for us as lawyers and for our?
So I think, coming from a financial background, it's not particularly surprising that I would say that cash is king. This is a much used phrase, but a very true one in my view. And at the end of the day, we can only survive as businesses, all of us, me, you, your clients, if we have enough cash to operate. So my biggest point whenever I'm talking to people and pitching is to say, the way to look at this is to make sure that whatever deal is put together, everyone is going to have enough cash to keep themselves happy. But also, litigation finance, because it's risky, is expensive. So it's very important for people like me to manage expectations at the outset and to say that this money is expensive, but perhaps without it, you can't progress this case. You can't get to a conclusion. So although in absolute terms it might be expensive, this is going to enable you, the client, to get a really good win at the end of the day that you wouldn't otherwise get. And I think it's very important to do that. And I would say a takeaway is talk to us early. We can help manage expectations in terms of the numbers, but we're always going to be looking at cash flow as a first instance because, as I mentioned, cash is king.
Peter, this has been such an informative and a really interesting interview. We appreciate your generosity, not only with your MCLEs, but your presentations and for making this presentation today. Thank you.
Well, Hilary, thank you very much. It's a great pleasure to talk to you. And I do thank you from our side as well for giving us this opportunity to tell you and the audience a bit more about what we do and how we do it. And we would love to work with all of you going forward.